Good afternoon, class.
Good afternoon, sir.
Thank you, and welcome to today's class. I believe the coordinator is here already. I would like to know where we stopped in this particular class. So please, is anyone willing to point out or to remind us of where we stopped? Yes, Ugochi, please go ahead.
Good afternoon, sir.
Good afternoon.
Sir, we stopped at civil and criminal law.
Civil and criminal. Okay. That's under the classification
Of
of
law, sir.
key. Just a minute. All right. Is this ICE class or regular 100 level?
Regular 100 level.
Regular 100 level.
All right.
Regular 100 level.
Okay, no problem. So we'll take it off from there. And why I asked is that the ICE 100 level appears to have been attending the classes I had prior to when we actually started. Because in the last class we had, we decided to have an interactive section. And I was indeed very impressed by the various submissions they made, and which shows how much of time they have dedicated to studying the course. And of course, I think I saw a lot of traffic on this particular course on my YouTube page, which is more or less people going to listen to the topics, because the kind of discussion we had even gave me the mindset that our classes henceforth will be interactive. So that's a way of confirming the extent of your commitment to this. But as of course, we will continue with what we are doing here. So for those of them there, it's maybe an added advantage if they have to discuss the topic with me. But I think the style we adopted for this class is the lecture style. But that will not also stop us from engaging in the interactive style of teaching, which I believe is also another very profitable means of learning. All right, so we move on from that point to start by looking at substantive and procedural law. Okay, substantive and procedural law. Oluwole, please, you can reach out to Isaac in case the IC students are free. They can join
Okay,
this
sir.
because already I've given them assignment on this topic and even the next one we're going to discuss so that it can help them to prepare appropriately for that class. All right,
Okay,
so
fine.
we'll start by looking at another classification of law, which we have tagged substantive and procedural law. Now, when we talk about substantive law, we simply talk about body of rules or legal rules. And this is the kind of law that categorically stipulates what conducts are permissible within the society. And apart from the fact that they stipulate the conduct that are permissible, they also make known the punishments that can accompany default or refusal to follow the laid down rules. So, strictly speaking, substantive law provides or educates, or so to speak, make available acceptable conducts and those that are not acceptable within the society. And like I said earlier, it's not just about listing the offenses or the provision of the law, it will also provide for the punishment that may accord such violation. So, a breach of substantive law can lead to remedy or punishment. Okay, remedy which may be in form of compensation, which may be in form of fine, or even in form of terms of imprisonment. And this particular class of law, which we have labeled the substantive law, deals with subjects like the criminal law, the constitutional law, the law of contracts, law of torts, and so on and so forth. And of course, all of these laws basically stipulate or deals with statement of rights, duties, and liabilities of parties in the society, probably one to another. On the other hand, when we talk about the procedural law, it concerns the approaches of proceedings to enforce a particular right or duty, or how the litigation is conducted, or the format to which a particular course of action is to be presented in the law court. So, therefore, the class of law referred to as procedural is also known as adjectival laws. And that's why if you have a case, for example, it is this law that tells you where you can institute such actions. Apart from instituting the action, the condition precedent to institution of the action is also provided for by this class of law. So, it is the kind of law that govern the application of substantive law. That is how the substantive law are administered within the society. Obi, you are raising your hand. You have a question?
Yes, sir. Please, sir, can you please come again for the definition of procedural law?
I said procedural law is concerned with the approaches of proceedings to enforce certain rights or duties, or how litigation are conducted in the court of law.
Okay, thank you, sir.
Okay, so that is also known as the adjectival law. And like I mentioned earlier, when you have a case probably bordering on substantive law, it is this adjectival law that lays the methods or the process that is required for you to initiate the action in a court of law. Apart from that, it deals with the mode of proof, how you can establish a particular issue or fact in issue. Whatever it is that you are presented to the court, the procedure for proof is practically not general. Therefore, when you are required to make your case, how will you go about it? The procedural system, the procedural law guides you on how to do that. And then, what about the manner of prosecution of evidence? That is how you give evidence in the law court. Even the manner at which the court will give its judgments. And apart from, even when the judgment is given, there's also the requirement to know how you can enforce the judgment that has been given. For example, if you are a landlord, you have taken your tenant to court, and luckily for you, the court found in your favor and gave a judgment to the effect that your tenant, whom you have brought to court, probably requesting the court to ask to evict the individual. Now the court has given you judgment that you are entitled to possession of your property. Then the question is, do you then go to the tenant and throw his things out because the court has given you judgment? If that is not the case, how do you approach enforcing the judgment that has been given to you, or what we call reaping the fruits of the judgments? So, therefore, all of these, how you can enforce it, what you must do, are business of the procedural law. And that's why you will see legal instruments such as Sheriff and if I recall the full name, I'll share with you. These are laws that guides enforcement of judgment within a legal system. So, and another thing you need to note about this is that The procedural law is the rule of practice and procedure which stipulates how a right or a duty prescribed in a substantive law should be enforced. For instance, with reference to enforcement of criminal law, procedural laws specify the court vested with criminal jurisdiction, the procedure for initiation of the criminal action, proof and admissibility of evidence, even punishment, and the right to appeal if the individual is not satisfied with the judgment of the court. It is the procedural law that will say that in a case of alleged murder, the magistrate court as a lower court does not have the jurisdiction to hear such a case. All of this is governed by procedural law. That this is the kind of court that is saddled with the jurisdiction to entertain such matters. So therefore, procedural law deals with all laws except for procedural law itself. Then we have examples as in constitutional law, criminal law are all examples of
I mean, I
substantive
have idea for
law.
second.
See, the criminal law, the constitutional law are examples. So basically, procedural law are civil and criminal. For example, the recovery of property laws
Maybe they
and
don't start.
high court high court rules of the various states.
Come here, you cannot.
Come here. So you
Or-
cannot. You say.
You cannot. Two of you cannot do.
That is good. Come here, Ace. Come here.
I'm glad you can hear what one of
You come and say
your
you
class member is doing on this call. It's terrible. Please mute yourself if you are not talking to us here. So we have the various high court rules for each state. What those high court rules do is that they lay down the rules of practice. They lay down the procedure of practice and so on and so forth. So in distinguishing between substantive and procedural law, we can see that one lay out the actual law, while the other one prescribes how the substantive law can be applied. So those are the two, just the major difference between the two systems of law. So before we move on to the next classification, which is written and unwritten law, is there any question on this before we proceed? Okay.
Good afternoon, sir.
Yeah, good afternoon.
Sir, I don't really understand the procedural law.
Procedural law deals with, permit me to use the word procedure, of how the substantive laws are enforced. Okay? We said substantive law includes criminal law, contract law, laws that deal specifically on murder, like say murder, for example, theft, It provides for that if you do this, that means you have committed murder. If you do these kind of things, what you have done is theft. Those are the kind of laws that are referred to as substantive law because they lay out the law itself. Why the procedure law talks about the rules and the processes for enforcing substantive law, meaning that if an individual has been alleged to have committed murder, how do you deal with such cases? It is the procedural law that deals with that.
Okay, thank you, sir. Sir, so for instance, if a murder case, they say that they should hang the person now, and them carrying the process of them carrying the person to go and hang, that's the procedural law, right?
How did they arrive at going to hang the person? It's the matter of procedure. You know, you just wake up to say the person should go and they should go and hang the person. That means the person must have faced trial. Must have had the
Yes.
opportunity of saying his own side of the story, and the court must have listened to them, listened to the evidence they have provided, and come up with a decision. Even the process of coming up with a decision, there are procedures that the court must follow. Okay?
Okay, thank you, sir.
All right.
Good afternoon, sir.
Yes, good afternoon, Fee. Follow
So I
up.
wanted to confirm, did you say procedural law is the same as adjectival law?
Yes, ma'am.
Okay, thank you, sir.
Yes. Mausi.
Good afternoon, sir.
Good afternoon.
So when I was reading, I was trying to like come up with examples because like that's what makes me remember things. And my examples seem so light. So I don't know if they fall under a different thing because like the examples you have been given are like so rigid. I just wanted to give you one of my example.
Go ahead.
So if for example something happens, maybe I don't know, but something happens and then like what's it called? Police or whatnot are they're directed to search a house. So is procedural is sorry, is procedural law what says that they should have a search warrant before searching
Yes.
the house?
Yes.
All right, thank you.
That's the procedure. Meaning that if they don't have the search warrant, they have not followed the procedure. That's why I said earlier that when you have a court judgment, you don't go ahead to chase the tenant out by yourself. You still go to a particular section of the law that will mobilize to do that on your behalf.
All right,
Okay.
sir. Thank you, sir.
Yes, you're welcome. Okay, so let's take Oluwaseun before we move on.
Alright, sir. Okay,
Yeah,
just like Mausi said, like I came up with an illustration. I just wanted to confirm it with you.
go ahead.
Okay, so you're saying we can liken substantive law as the blueprint for a building, while procedural law is the set of steps and tools needed to construct the building, and without the blueprint and the steps and tools, the building cannot have a complete structure. So also substantive and procedural law are needed for the legal system to be complete.
Yeah,
All right.
you're correct. Okay, so let's quickly move on to the next one, which is written and unwritten law as a class of law. Written law is a rule that has been formally enacted into a legislation or statute by the legislature. Now, what we refer to as written law, just as the name implies, it is written. And it is not only written, but it must have passed through the procedure for the procedure of enactment. By the time we are looking at the sources of Nigerian law, we'll talk about Nigerian legislation as an example, and we'll take time to look at the various steps in which a particular bill will have to pass through before it eventually becomes law. And once it passes through that particular procedure, it is documented and then it's referred to as a written law. It's different from laws that are not written, but they are in operation. Now, such laws, that is, this written law, are debated and scrutinized through various stages, like I explained. It's not just an idea of you bringing it out and then it becomes law. It will pass through series of proceedings. We'll say first reading, second reading, third reading, committee stage. Then it can even go, you now move to the other House of Assembly. Other parts, like in case of National Assembly. If it started from the Senate, it will still go to the House of Rep for them to look at it. So all these procedures are expected to be followed before they can become a valid law. So written laws are usually found in documents. Written laws are usually found in the documents and can be said to be a combination of norms in one or more documents. And that's why we refer to them as codes, we refer to them as statutes, we refer to them as acts, we refer to them as edicts, ordinance, and so on and so forth. Because they are written, they can be contained in a single document or also in a series of documents. Just the way we have our constitution now, just the way we have what we call laws of federation. There are the various laws of federation that have been written down into what is now known as a body of law. So, and when they come out like that, in that form, we refer to them as either a code, statute, act, even laws or ordinances, as the case may be. So, example of a written law is the Nigerian Constitution. The Nigerian Constitution is an example of a written law. On the other side, an unwritten law are laws that are binding rules of conduct which the society and the court of law will enforce, even though they are not particularly written in a particular book. But the society have come to identify them through the court as binding rules that the society is bound to obey. So it may mean rules or principle that is not written down, and such as, like the customary law, for example. They are not written anywhere, but one way or the other, by practice and procedure, we've identified some laws that are customary law, even though they are not written. I think sometime back when I was teaching this course, this topic, I gave an example of two people intending to be married. In our society, for example, in Nigeria, for example, when you want to get married, there is this requirement, rules, that you go to the wife's parent and indicate your interest. Apart from indicating your interest, you'll be made to part with some things as a form of customary law or norms before you eventually, formalize your intention to marry their daughter, even though it's not written anywhere, but they are enforceable within our society. That's why in some communities, if a man impregnates a woman and that union brings up a child, in some community, the community will not refer to the product of that relationship as that of the man, because the man has not fulfilled some traditional rights. These are rules of custom that, even though they are not written, but they are being recognized by the court, and such they are seen as customary law. So basically, unwritten laws are laws that are not written. So sometimes they may be enacted, but mostly they are unenacted. For example, the Nigerian legal system, under the Nigerian legal system, customary law and the received English law are written and unenacted laws, just like I've explained before. Then the British Constitution is an example of unwritten law. Okay? Why the Nigerian Constitution is an example of a written law? Because it's contained, is codified in documents that can be referred to as laws in Nigeria and are enforceable within our legal system. Yeah, somebody has a question?
Sir, is it still okay for us to describe written law as a set of laws that are codified in a single document?
Yes.
Okay, we can still define it that way.
Yes, please, you are correct.
Okay, sir.
Yeah.
But does it also apply to the ones that are like not in one document but in different documents?
Can you repeat your question?
Sir, I'm saying, is written law only limited to laws that are codified in a single document, or the ones that are codified in like different documents, are they also included?
Once they are codified, automatically they become written law. The ones you use the word codified,
Okay.
yes, they are. When a law is not codified, that means it's not written.
Okay, sir. Thank you, sir.
You're welcome. Yes, somebody else is raising hand.
Good afternoon, sir.
Good afternoon.
Sam, I have one question to ask. So,
Okay.
is it that Nigeria is he actually practicing written law and unwritten law together, or just written law?
Our laws are majorly codified, apart from the customary laws. Okay?
Yes, sir.
Yeah, you see, you can come across criminal law, our criminal law, criminal code, criminal penal code in the north. You can come across administration of Criminal Justice Act, the NDLA Act, and several others. They are largely codified, except for customary law that are not, codified. Yes.
Good afternoon, sir. So I have two questions.
Okay.
How do countries like Britain and France that use unwritten laws, how do they keep track of their laws if they are not codified into a single document?
Well, the good thing about it is that the practice leads to general acceptance if you were in class when we were talking about international customary international practices, that there are some things that have become like international law, even though they are not written anywhere. So it is a matter of practice and consistency that leads to such, such law. And once they are known, it becomes just part of the system without any form of doubt on its existence and usage. Do you understand?
Yes, sir, I do. Thank you,
Okay.
sir.
Yeah.
Well, my second question is that what kind of legal punishments are enforceable for unwritten law? I would appreciate maybe one or two examples that can illustrate the kind of punishments that unwritten law for unwritten law.
Okay, take your mind to our customary law system. In areas where customary laws are applied, of course, you agree with me that they are not written. When a man commits a taboo, what kind of punishment do they give him?
He could be shunned from society, or they could ostracize
Ostracized.
him.
That is an example of the punishments that you ask.
So if let's say, for example, under customary law, if a man refuses to pay bride price, can the family of the woman take him to court for customary?
The only area that the court may come in, or maybe the traditional court anyway, is where the man, because I think in Igbo land, for example, I understand that if you, as a man, you impregnate a woman and then the woman becomes pregnant and give birth to a baby, that the tradition does not allow the child to bear the name of the father if the father has not paid the bride price for the mother. So the customary system also has a way of enforcing its own rules and regulation, which may not necessarily be that you have to go to the court. Because also, even the customary court system, the customary law system also have their own different method of adjudication, even though we may end up referring to it as court, but they have their system of adjudication. Sometimes it may be by the council of elders that we look into the matter, or even the chief priest sometimes play all of that role in a customary system. So generally or usually it will not be like a formal court, but the issue are also adequately addressed. Okay? All right,
Yes,
so
sir.
I think we stop on that so that we can move on to the next topic, which is the topic 2 of our scheme of work. And then we'll be talking about historical development of Nigerian legal system. That is the topic that we want to look at right now. Historical development of the Nigerian legal system. So we want to look at how we are fared as a nation, especially as it relates to our legal system. And as we look at this topic, our discussion will cut across 3 main timelines, and it covers the major political development of the country. So the 3 main major timelines are number one, the pre-colonial judicial administration, the colonial administration, and the post-colonial judicial administration. So if we look at these 3 points under this topic, we will have been able to explain how we started before we were colonized, how we fared or survived during colonization, and how we are faring right now, even after we have become an independent nation. So, first of all, we are going to take on the pre-colonial judicial administration. So, simply put, the judicial system in Nigeria has developed over decades. And development, they move from one stage to the other. They move from different stages affected by different system of government. And prior to colonization in Africa as a whole, so to speak, our indigenous traditional systems had their own system of had their own judicial system, so to speak. And this their judicial system, they are responsible for the administration of justice in the society. Meaning that when an individual has committed a crime against the society, their judicial system, they are able to cater for it. And that was why when I was talking about customary law as a system of law, and I asked that if a man is seen to have committed a crime in the society, a taboo, for example, how do they punish him? Sometimes they make him to dance around the market square, which is a form of humiliation, because, of course, when such is done, the individual will refrain from doing anything that will lead to shame next time. For example, when you watch the TV and you see where some alleged individuals are being taken to court. Oh, this individual have been arrested for committing a particular crime. And then they take them to court. You discover that when the videos or the cameras are being zoomed on them, some of them will cover their eyes. Then there was a time when a woman killed the husband in this country. And every time she goes to court, you will hardly see her face. She will cover it. Why? Because she's probably ashamed of the situation that is on ground. So that was a kind of punishment that was common at the pre-colonial era. Some you banish them, some you put them in the king's prison, some you make them to do community work, either to go and clean the gutter, clear the bushes, and so on and so forth. What we know basically is that the system as at that time catered for the various needs of the society. They were able to manage cases, they were able to settle cases, irrespective of whatever kind of case, be it chief tenancy title, be it issues relating to land matters, be it issues relating to inheritance, be it issues relating to contracts, that is buying and selling, and so on and so forth. The system in place as at that time were able to cater for this. But nevertheless, the entry of the European commercial actors into the society began to bring about some level of development into the judicial system. And that serves or could be seen as the foundation for the future of the contemporary adjudication system that we have in Nigeria today. When those commercial actors were coming into Africa, or let's say when they came into Nigeria, for example, since our focus is on Nigeria, they came with their own system of law. And this system of law can be said to be what now form the foundation of what we practice today as a people. For instance, in the 19th century, before the annexation of Lagos in 1861, different societies that now form what is now known as Nigeria, or even African countries, had their own political system with their own method of administration of justice. At that time, there were traditional courts where traditional rulers or traditional rules were applied by traditional rulers. And then, irrespective of whether the individuals were indigenous or foreigners, the system of law that was in place at that time was also able to cater for them. Once you live in a society, you are bound by the rules that govern the society. When you look at the Igbo land, for example, there was an acephalous system, which is a society without central leadership, meaning that leadership was distributed among members of the society who sat in council to exercise the various powers that a modern government will have. For example, these people exercise judicial powers, because among these people, traditional rulers that sit in council, you have people that perform the role of judges. When you see the chief priest, they function in such capacity. Apart from that, you also have part of those that sit in council that serve as the lawmaker, the council of elders. They are the ones that determine what law is. Then, above all, you have the executive, who is seen as probably the head of the setup that ensure that the law that has been made by the various organs of the society, whether by the Eze in council or the kingmakers or whichever group of people that the society has saddled with the responsibility of lawmaking, you see them that they perform all these functions. And even within those that perform the executive function, you will notice that we have even police. They have their own system of police that ensure that the rules of the society are obeyed. When you look at the justice system in the pre-colonial Hausa communities in the northern Nigeria, it is what is seen as what is the closest to what we have today. Okay? So, in essence, all over the place that is now known as Africa now, or Nigeria, the various groups that existed there had their own system of law. So, in the Hausa judicial system, there was a court system in which subordinate chiefs or alkalis headed court in different districts or zones. And the emir had the appellate jurisdiction or original jurisdiction in very serious cases. Even when you take your mind back to when we were looking at common law, we did say that the king had a lot of power to the point that he could attend to petitions that came from the people that were not, that common law were unable to meet their needs. So, and we did say that where the court of the common law court is not able to adjudicate properly, that the court of exchequer served as appellate court. So meaning that in their own system, while they had all of those things, even in the Hausa territories, they also practice all of these things. So, and again, what kind of rule did they apply? They applied majorly unwritten customary rules, interpreted by the institutions and individuals that exercise judicial powers. Those in the community who exercise, who deal in customary rules or management of the society, they are the one that administer this justice or these unwritten customary rules that helps the society to thrive. And then social punishments such as ostracization were very common, as well as corporal punishment. They could send them away, they could even kill, they could even amputate their hands, or they can amputate a sensitive part of their body as a form of punishment and to prevent them from having a reoccurrence of the evil that they have done in the society. So, as time progresses, the foreigners that had interaction with the local people also were governed by these rules. So what happened at that time is that the judicial system of many of these societies applied native and non-native, applied their rules to natives and non-natives, even when the non-native does not even understand the rules of the custom that applies there. But by virtue of the fact that such an individual is found, seen in the society, is to obey the rules that operate within the society. But with the increasing growth in European trade in the region, British traders became involved in the politics of the region and the judicial administration. So the traditional system of judicial administration posed a problem for foreigners, particularly European foreigners who were unfamiliar with traditional laws in many of the African societies. But like I said, what happened was that the rule applied to them at the system because of their presence within that society. But with time, we saw a situation where problems came up when the laws, these customary laws, were to be applied to natives and even those who are not natives of that particular society. And this was what led to the introduction of the consul court. The consul is spelled C-O-N-S-U-L, courts. You can spell court. So the British government introduced the consul court. And what they did was to appoint consuls to handle disputes between indigenous and foreigner traders. And then they succeeded in making the traditional court to continue to administer cases involving indigenous. But when they had cases that has to do with indigenous and foreigners, the consul court addresses all of that. But one thing you must note is that in application of that, they will have to apply some foreign rules that are not indigenous to the people of Nigeria. Okay? So, but they had to apply those rules in order to manage the dispute between the traders and indigenes, and between indigenes and non-indigenes. So, we have example in the Oil River Protectorate as, what the British government introduced into Nigeria. That Oil River Protectorate, which later became the Niger Coast Protectorate, for which councils were appointed by the British government to observe treaties and handle the governments of British subjects in the area. So, by that introduction of the Oil River Protectorate, the British government began to solidify its presence in the area. And the Oil River Protectorate, happened within our jurisdiction, and then it later became known as the Protectorate of Southern Nigeria. And the Court of Equity had been introduced in the mid-19th century, with the main function of administration of commercial relations between British subject and British subject and non-British subject. This will first of all tell you the intention of our colonial masters, that probably most of what that they did was to their own benefit, because one of the things that led to the introduction of consul court was the fact that the customary law system was not able to meet up to manage and address issues that were coming up between the citizens and non-citizens, especially in the area of commerce, because it was commerce, economics, that brought them into Nigeria in the first place. So, the main aim of the Protectorate of Southern Nigeria and the introduction of equity as a system of law was to administer justice to all and sundry. And then they were different from the consul court in that they were less technical and related more to the administration of commercial relations than government and justice. Their focus then was how they could manage their commercial activities by either enacting law or enforcing law that will be favorable to them. And what we say is that by reason of this demarcation, it became the beginning of the division of legal system of Nigeria. Okay, number one, there has been introduced some, consul court. Apart from consul court, the Oil River Protectorate, Southern Nigeria, has started performing all these functions put together. So, with that, and with the coming into effect and coming into full force of the colonial masters, we now transited into the colonial judicial system. In the colonial judicial system, we now saw the full intervention of the British, or those who came to colonize us in Africa. And then we entered into the realm of colonial justice administration. So we want to look at the colonial justice administration. To start with, we can discuss the colonial justice administration in two ways. Number one is the pre-amalgamation, and the other one is post-amalgamation. The pre-amalgamation period causes the period between 1861 and 1914, when different parts of Nigeria is now known as Nigeria, were administered by the British government or its subjects. So the post-amalgamation period refers to the period after the amalgamation of the colony and the protectorate of Southern Nigeria with the protectorate of Northern Nigeria to form what is today recognized as Nigeria. So, therefore, when the cession of Lagos to the British Crown in 1861 took place, the Supreme Court Ordinance of 1863 established the Supreme Court in the territory of Lagos. And that was how the Supreme Court, started in Lagos before it was moved to Abuja. So, the Supreme Court of Ordinance 1863 established the Supreme Court in the territory of Lagos, and it was subsequently helped by the Court of Civil and Criminal Jurisdiction. That is, both the courts would now administer criminal jurisdiction at the same time administer civil jurisdiction. Yes, I can see one hand up. You want to ask a question? Please go ahead.
So, please, I wanted to ask you to rephrase. I did not get what you said from the post-amalgamation era or something.
Okay, I will recap. I said the post-amalgamation period referred to the period after the amalgamation of the colony, that's the colony of Lagos. When Lagos was taken over, it was seen as an extension of the British government. They didn't see it as part of Nigeria. They saw it as something that they have captured. And then it's part of their country. So when the Lagos colony and the protectorate of Southern Nigeria with that of the Northern Nigeria were merged, and when eventually when Lagos was ceded to the British government in 1861, The Supreme Court Ordinance of 1863 now provided for a Supreme Court in Lagos to make it, of course, begin to have that national outlook. And then this particular Supreme Court ordinance, which established the Supreme Court in the territory of Lagos, and then it was subsequently replaced by the Court of Civil and Criminal Jurisdiction, meaning that the Supreme Court then not just serve as an appellate court, but helps to determine civil and criminal, matters. And that's why up to today, different kinds of matters are sent to the Supreme Court for, for hearing. So, and at that time, the Supreme Court was the highest court in Nigeria. And then when the matter has been decided and the individual is not satisfied, he is enabled to appeal the case to the West African what we call WACA generally. Okay, WAC, West Africa Court of Appeal. Okay, it was when appeal gets to them, it's laid before the Judicial Council of the Privy Council, and this Privy Council was still a formation of the government that has come to colonize Nigeria. Okay, but in 1874, the Gold Coast colony, that is the Ghana that we have today, was established, and then it now comprised of Lagos and the Gold Coast. And the Supreme Court Ordinance 1876 provided for a Supreme Court for the colony, which will apply common law, doctrine of equity, and statute of general application that were enforced on January 24, 1874, as we have discussed earlier on when we were looking at, or maybe when you joined the class, when we were looking at sources of Nigeria law. So, what we are saying, consequently, is that there was development in line with the formation of the Supreme Court. And the court not only apply its own rule, apply the common law, doctrines of equity, and statutes of general application. So the three-tier court system had a hierarchy consisting of the District Commissioner's Court, the Divisional Court, and the Full Court. And of course, appeal from a lower court or from any decision that was taken in the established court for the country at that time, we appeal in that order. But by 1886, Lagos ceased to be part of the Gold Coast colony, and the colony and protectorate of Lagos, comprising of Lagos and surrounding protectorate, had a Supreme Court established under a new Supreme Court ordinance. This was with similar provision to the 1876 ordinance. Okay, it's of a similar provision, just that the law now is being reenacted to bring up a new Supreme Court, to the land. But during this old time, the judicial court system also continued to flourish, though it was limited to cases involving freedom, some of whom had imbibed the English way of life and subjected themselves to English law. But what we maintain is that despite the availability of this newly introduced system, the indigenous court system continue to perform its duty, especially perform duties that require traditional rules and help to, do what a normal court will do. So, but at the same time, the English system has already been introduced, and then while the other one mainly treated issues that are related to the indigenes and the non-indigene, the English system dealt with cases between indigenes, between foreigners and indigenes, and foreigners alike. But we needed to note that what began as a wholly commercial relationship between Nigeria and the colonial master later became a complex political relationship in which the British Crown dominated the political scene in Africa. That's why we call it colonization. And this can be seen in the experience of the Royal Niger Company, which began as a national African company, a company doing business in the territories among the rivers. The company was empowered to administer justice in the territory where it operated. You can imagine a company serving as a judge, and so on and so forth. And after the 1914 amalgamation, the bifurcation continued, and there were proclamations establishing a new Supreme Court, a provincial court system, and a native court system, respectively. But individuals could subject themselves to any of the systems that had been created by this new development. So the court were empowered to exercise jurisdiction in civil and criminal cases, even concerning natives. But certain classes of natives were subject to the jurisdiction of the court only if they or the residents consented to it. And then, why people we refer to as lieutenant governors handled, other cases that are criminal. Okay? So, in the community, some of them now began to subject themselves to the customary system, like I said earlier, and the other were also tried by the new courts of the British that have been introduced. So, and in some cases, some government official or government servant were also made to be subject to the English system and did not, subject themselves to the customary system that was in place as at that time. So, but the whole system continued in this form, and there were quite a number of judicial reform that took place. Example is the introduction of the High Court, the introduction of magistrate court that we now have today. All of them, came into place during the colonial system. Also continue, even though there were a series of cases where they had to repeal them, They repeat the law setting on the Supreme Court. Another one will also be enacted in order for the system to continue. But jurisdiction in matters related to English law was shared between these courts, which had original and appellate jurisdiction. Later on, we'll talk about what original jurisdiction or appellate jurisdiction is all about. But just like we have it now, as at that time, appeal from magistrate court moved to the High Court, and from the native court to the magistrate court or the High Court. While appeal from the High Court and the Supreme Court were laid before the West African Court of Appeal, which is popularly known as WACA. So the system of judicial hierarchy, where we will say one court is lower than the other, and if a judgment is given in that lower court, you are not satisfied, you can move to the higher court, until you get to the #1 court in the land, where the common practices that took place during this time that the judicial system of Nigeria was developing when the colonial masters were fully on ground. And then this particular system, both the native court system, I repeat again, and the English court system, all of them continue to exist side by side. As a matter of fact, there were also establishment of customary laws, there were establishment of other native courts to handle some specific matter. Like in the northern region, Islamic Sharia law was the recognized customary law there. While in the southern part, they have their own system of customary law, which did not amount to Sharia. Okay, Sharia had their lower court. They even had Sharia Court of Appeal, where people who were not satisfied with the judgment given by the lower court or the Sharia court could go to the Sharia Court of Appeal. So these were the major developments that took place during the colonial history, or the colonial, that relates to judicial administration during the colonial administration. Mainly, the interaction between the colonial masters rubbed off and dictated the various changes that took place within our judicial system. And then, as time progresses, Nigeria became an independent nation, and upon that, we now moved into what is known as the post-colonial judicial administration. But we're not going to discuss that for today, because it's a bit of history and it may look boring and confusing to some people, but at the same time, we just have to deal with it. So when we meet in our next class, we are going to be looking at the post-colonial judicial administration, and that will show to us the events that took place during the post-colonial system in Nigeria, especially times when we consider that we have advanced in age and in many things. Therefore, a lot of new developments, a lot of courts initiatives were also deployed in the post-colonial judicial administration. So that's where we're going to end the story of today as it relates to the historical development of the Nigeria legal system. I don't know if there's any question before we call it a day. Yes, Miriam.
Sorry, sir. I just wanted to ask if there's a way we can get today's lecture in form of a note, because it's quite a lot, and with not everything we'll be able to get down in our notes
You
or
can listen
like
to
mentally.
the recording again on my YouTube channel. It is
Okay,
easy.
thank you.
Definitely history will appear boring, but it's also something you have to learn. And thank God the recommended textbook we give you also contains a bit of this history it's also simplified them in some ways. Okay, Precious.
Thank you, sir.
If what's the stages of judicial development in like an exam or test, is there any specific structure we should follow? Because it feels like some of the history overlaps at some points.
Yes, that's correct. There's no specific format to follow because history many a times come in different ways, like we saw repealing and enactment of laws, but whatever it is that you are writing should be able to showcase your understanding of the development. It is the progressive part of it that we are actually interested in. Okay?
Okay, sir.
All right, so we'll call it a day here. And by the time we reconvene, by the grace of God, we'll continue from there. So thank you very much for listening. We already have your attendance taken via the participant as column. So you are covered for the day. Thank you and enjoy the rest of your day. Bye-bye.
Thank you, sir.
Thank you,
Thank you, sir. Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Sorry, please, how are we meant to
Thank you, sir.
Radio.